Okay, it's time for episode 3 of Self-Evident Truth with the Angry Old Vet. Um, Yesterday we had the 6th, who was my lovely wife's birthday. We had a court hearing at the Hillsdale County Circuit Court, but they held it in the probate courtroom where you could only get a few people in, so the entire rotunda was packed with patriots. And thank you to all the patriots that showed up. That really means a lot. Because after all, when it comes down to it, in this republic, it's all about the people, we the people. And so it was good to see all those people show up and show their support for the America First patriots that are in the middle of this fight. One of the things that was brought up by their lawyer, Jonathan Lauterbach, is he said this all hinged on the 825 meeting. That's the meeting, if you remember, where they decided to get together and they voted to oust all of the officers and then put themselves in as the officers. There's two problems with that. One, they accused us of violating the bylaws. That's why they were going to have this meeting. But in fact, they violated the bylaws. Now, their lawyer tried to argue that not inviting Jonathan Lindsay was proper because Jonathan, the redistricting and everything didn't take place until Jonathan swore in and was elected in November and sworn in January. Okay, I'll give that to you. Let's give him that argument. The problem is Mike Shirkey made motions and seconds in that particular meeting by their own minutes of the meeting. Mike Shirkey is an ex officio member. By the bylaws, ex officio members cannot make motions, they cannot second motions, and they cannot vote. The only thing they can do is participate in discussion, and that's all that they can do. Because one of the problems is Mike Shirkey is not a registered voter in the county of Hillsdale. He's a registered voter in the county of Jackson. So thereby, he had no vote. He had no ability to make motions. He had no ability. He had no ability to second motions, and so that was a violation of the bylaws. And under the unclean hands doctrine, then they're guilty of what they accuse us of being guilty of, which is violating the bylaws. Now, there was a case in Macomb County, almost identical to this case in Hillsdale. And the MIGOP lawyer, Dan Hartman, from and a Hillsdale College graduate, go Hillsdale, decided to write an amicus brief for this case. Problem is, it was late and it was quick, and inadvertently he sent the draft that he did, and not his final copy. But his draft was powerful, even so. And so I'm just going to go over the amicus brief. For anybody that's listening, an amicus brief is a brief submitted to the court on a particular case that that person is not a party to, but has a vested interest in the outcome of the case. And MIGOP would qualify in that instance. They have a vested interest in what happens in this case, and and of course the amicus brief has to be based in law. It can't just be, I've got a vested interest in a case that's coming out, so I'm going to write my opinion to the judge. It has to be based in law, and that's what an amicus brief is. So if you hear that, like I know with the New York case with the concealed carry laws that they're trying to put out right there. There was an amicus brief filed with the Second Circuit Court, Second Circuit Federal Court, and there was an amicus brief also filed with the Supreme Court in that particular case. That particular case also had what's called an interlocutory appeal that was put in, and that's an appeal that goes in prior to a lower court coming to a decision. You can go to a higher court and file an interlocutory appeal. So I just bring that out because we should be learning new things all the time, and the law is a good thing to learn because we're all subject to it. So going back to the case, Jonathan Lauterbach said, well, everything hinges on that 825 meeting by the Brent Leinecker group, or what is known as the Shirky-Leinecker faction, okay? So this is the amicus brief that was written. Attorney opinion on MIGOP as implicitly requested by the court on February 2nd, 2023, in the order denying the TRO relief. Now comes the Michigan Republican Party State Committee, MIGOP, by its attorney, Daniel J. Hartman, who offers this court the following opinion by invitation. 1, MIGOP has had a change of leadership that was effective on February 18, 2023, and is still in the 30-day transition of obtaining records and forming a new leadership team. The order of February 2nd, 2023 essentially invited the MIGOP to resolve this matter as an intra-party dispute. Therefore, on behalf of the MIGOP, this document will set forth the way in which the matter should be resolved. This is based on a review of documents and pleadings filed in the matter. The Michigan Republican State Committee, MIGOP, is the state political committee of the Republican National Committee and is authorized by law pursuant to Michigan Compiled Law 168.597. There are 3 political committee types in Michigan: 1 state central committee, 13 district executive committees, and 83 county executive committees, which comprise the Michigan Republican Party, MCL 169.211.6. There can only be 1 county executive committee, 1 recognized committee. That's we've cited 169.211.6 before. 4, delegates are elected in the state primary after registering to be on the primary ballot. Other delegates can be appointed by the county convention to fill vacancies in a practice called elevation. The delegates are the base of the party, and there is often changes within the party and some internal upheaval during changes. This is such a time, and the party should be able to disagree but follow orderly established rules for resolving disputes. See, again, that was one of our arguments, is they've always had an administrative remedy, and they've never exhausted that administrative remedy. They went right to lawsuit because they couldn't get the AG to prosecute us. They wanted to prosecute us criminally. These are your county executive, or these are your county elected positions. MIGOP has standing and an interest in ensuring the process. So because they have an interest, he can file the amicus brief. MIGOP has a standing and interest in ensuring the process of both the access to the primary ballot for the election of delegates, as well as the process for removing or filling vacancies of delegates, as this creates the members of the party that are able to attend county conventions, state conventions, and district conventions and caucuses. However, MIGOP does not govern the district or county committees as vassals. Court action in party policy is forbidden by law, but the Article 3 power to redress disputes about process issues and when law and rules have been violated remain. 6. The issue and dispute begins when the Hillsdale County Executive Committee, which was formed after a call to convention in the fall of 2022, from elected delegates who were elected in August 2nd, 2022 primary, and certain statutory members that were on the ballot from August 2nd, 2022 primary, from the same August 2nd, 2022 primary. There were 2 calls to convention and 2 meetings held, which resulted in 2 groups asserting they are lawfully elected as the executive committee. 7, in capital letters, None of the defendants participated in or were elected at either convention, and therefore there is no dispute before this court. Simply, there's no dispute because the original 6 that are being sued stepped down. And that's the beautiful thing about the Hillsdale Republican Party. It's not a bunch of sheep. There are great leaders that are coming up in that party. We promote leadership, and and just everyday citizens with leadership skills stood up and said, okay, if those 6 are court ordered, they can't be here, they can't do it, we'll take the rules and we'll follow the rules and we'll do it ourselves. And they did. And that's the American spirit. That is the spirit of the patriot. So going on, the new executive committee dispute has other parties and is a new controversy. This matter was concluded on November 17th, 2022, when the new convention both occurred and the defendants resigned and declined to participate. In short, this case is moot. Even the issue as to the delegates to the February 18th, 19th state convention and district caucuses is moot. The matter should be dismissed. 8. However, an initial and outstanding collateral issue exists in that certain Republican delegates have claimed that they were prohibited unlawfully from being on the ballot by the Hillsdale County Clerk, Marnie Cast. These allegations are supported by statements in the preliminary issue before this court. If this process was corrupted by misfeasance or malfeasance of office, then this will affect the legitimacy of the 2022 County Convention that selected the Hillsdale County Executive Committee. This is an issue of fact within the Article 3 powers of the Circuit Court, and if a county clerk, as alleged, failed to provide access to delegates for the primary, then there will have to be redress. There were 26 individuals who submitted an application but were denied access to the ballot, of which only 2 were successful as write-in candidates. About 5 additional members were denied applications to be on the ballot. This issue is not before this court, but should be noted as a concern by MIGOP, who will investigate. So there will be an investigation into that. Now that's really the crux to what started the whole thing, was them meeting in secret and them fixing the 2022 precinct delegate election in Marnie's office. The duties of the clerk are a matter of law in MCL 168.605 to 609 for the selection of delegates to be eligible for the convention. 10. A second outstanding and collateral issue is that in April, the precinct delegate allocation was dropped from 133 delegates to 100 delegates by the determination of the county clerk, the probate judge, and the county treasurer. This decision is claimed by some to be arbitrary and capricious decision, and resulted in gerrymandering and Republican Party delegates to control the party through this means in favor of faction. That's exactly what happened. This is not before the court, but is a concern, and MIGOP will investigate. And that was the big question. Why did Marnie drop us from 133 to 100 when the Democrats have 102 delegate slots and only 1 person applied to be a delegate in the Democrat Party? We had 133 slots, and Marnie just arbitrarily dropped it to 100. And when asked, she really didn't have a good answer. She said, well, it was to save money on the ballot. So John Smith and Michelle Bianchi asked her if she could show the numbers, and she couldn't because she didn't have any, because this was a plot. It was a plot to overthrow the precinct delegate election in Hillsdale so that they could take control of the party. That's what this lawsuit's all about. Here's the third outstanding issue as to who leads the Hillsdale County Party and Executive Committee. This issue does not involve the current litigants and is therefore not properly before this honorable court. So this suit should have been over before it even started. Here is the opinion as to which of the two 2022 Hillsdale County conventions was lawful. It is the Manning Street Convention held on November 17, 2022, which is the one that was called for by Darren Wisely before the injunction, and the one that was authorized by MIGOP and on the MIGOP website. We must go back before there is a dispute, and this appears to be in 2020. At the fall convention, the Hillsdale Republican Party, an executive committee was elected in accordance with law, and this executive committee elected Darren Wisely as chairperson. His term of office was until December 31st, 2022, and the executive committee was until the term ended. This appears to be an upheaval that resulted in a change of factions within the party assuming control, and it was. This will create tension as the county party works out these issues. Well, they never wanted to work out the issues because when we did do it lawfully and correctly and take over the party, for 2 years, they never showed up. They wouldn't participate. They didn't want to participate. And then now during this whole time, they're throwing out these false flags of, oh, kumbaya, can't we all come together? We've invited you for 2 years. Where have you been? We've wanted you to get involved for 2 years. Where have you been? You can't not show up somewhere and then complain about how things are going and then plot to secretly take it over so that it can go your way. It's not how it works. B, let us start by recognizing that there are no methods for removal of the executive committee, which was alleged by the plaintiffs who claim that on August 25th, 2022. Now remember, Lauterbach said it all hinges on August 25, 2022. A faction of the Hillsdale County Party held a special meeting called and led by Mike Shirkey and Brett Leininger that met and claimed to remove the executive committee and officers. C, the defendants have asserted that there was improper notice, no opportunity to defend, and no determination of just cause for the removal for acts which would justify removal. Further, under the rules of the Hillsdale County bylaws for providing notice of a special meeting and what can occur at a special meeting, the removal of officers is unlawful as demonstrated by the minutes of that meeting. D, at the state convention held on August 27, 2022, MIGOP determined that the August 25, 2022 purported change of leadership was invalid, and this was reported in a letter signed by Ron Weiser issued on August 27, 2022. This should have concluded the matter. This was following a ruling in Macomb County on nearly the identical issue, opinion and order attached. He's got that attached. Now also let me bring up, remember the Ron Weiser letter of August 27th, which said that group of people who met on 8/25 are not seen as legitimate. That was the same letter that we presented to the Fair Board. And the Fair Board still gave the Fair booth to Leininger's faction because first the claim was that the letter was forged, and then they claimed that the letter was fake. Then they claimed, well, it doesn't matter what Ron Weiser says. Until, of course, they got their letter on December of 28th. Then that was like, oh, well, Ron Weiser said, so we have to follow it. They're hypocrites. Plain and simple. There's no other explanation. They're hypocrites. E, MIGOP has continued to recognize the officers of the Hillsdale Executive Committee as elected following the 2020 County Convention at the first meeting of their term through December 31st, 2022. This was until November 17th of 2022, when the officers resigned, even though this was prompted by a temporary restraining order issued by this court on November 15th, 2022, and delivered to them on November 17th, 2022. Nevertheless, the convention went forward and elected a new executive committee, which elected interim officers to fulfill the last part of the term through December 31st, 2022. There was never any election of the plaintiffs that is recognized by MIGOP. Now, you remember in Ron Weiser's letter of December 28th, they claimed that to Ron is we barred them from the November convention. That simply was a lie. So not only are they hypocrites, but they're liars. And we've got proof of that because Brett Leininger actually sent out emails and said, "Oh, that county convention being held at 7 South Manning Street at the old Wilson Hall is the wrong one to go to, even though that's the one that was printed on the MIGOP website." And that's the one right here that Daniel Hartman is saying was the proper convention. So Brent tried to get people to come from our convention to his convention and tried to claim that his convention was the right convention, even though it wasn't. So he was trying to usurp his own authority, and he was trying to thwart the system. He was trying to thwart, just like they did when they tried to overthrow by plotting to fix the 2022 election with precinct delegates. F, therefore, when Darren Wisely called the convention on November 17th, 2022 at the location 7 South Manning Street, Hillsdale, Michigan, and was listed on the state website, this was valid despite the court subsequently determining 6 defendants could not participate. Now, here's the other thing. That court order for that TRO only said that 6 people couldn't participate. That was the 6 original defendants. It never gave the party to Brett Leininger. Brett Leininger tried to say that that TRO made him the leader of the party. It surely didn't. There was nothing in that order that said he was the leader of the party. That's why when the group came together for the convention, that leaders stepped up and took over because the 6 of us officers were under court order not to be there. And we stepped down on the 17th. Why? Because we respected the rule of law, which they don't. Now, they claim that they respect the rule of law, but they don't. And it's evident that they don't respect the rule of law. Now, they go around throwing that mud at us that, well, they don't respect the rule of law. No, we did respect the rule of law. The judge ordered us that we couldn't participate, so we stepped down. And why did we do that? We did that because we didn't have egos. We did that because it was in the best interest of the party, not because of the ego. Why are they doing what they're doing? Well, simply because of ego. Nothing more. It's ego, power. All delegates were provided mail, text, and email notification. Some were hand-delivered, a few that were unable to confirm delivery. The MIGOP website listed this convention. This call to convention predated the court action. So yes, Darren's call to convention went out prior to the temporary restraining order, the injunction. The convention was run without the 6 people restrained by the delegates present in accordance with the law. That's what I said. Leaders stood up. The Shirkey-Leininger faction from the August 25th, 2022 date called a competing convention. This convention was held at the fairgrounds. This convention resulted in a competing executive committee being elected, creating the dispute. But it was a bogus convention. It wasn't even a proper rump convention. It was a bogus convention. The position of MIGOP is that this committee is an usurper and is not lawfully elected. So Brent's group by MIGOP is recognized as usurpers and is not lawfully elected. A court action was sought to determine the legitimacy of the officers. The court order on November 15th of 2022, the TRO restrained 6 members of the executive committee from acting, but did not address the legitimacy of the previous call to the convention. The result was that 36 attended the Manning Street convention and 24 members attended the fairgrounds. 2 competing, those are about numbers. 2 competing executive committees were elected, but only one is valid, and that is the Manning Street Convention, according to MIGOP. The controlling issue is whether a lawful convention was held at the fairgrounds by Shirky-Leininger faction of the Hillsdale Republican Party. Now remember, Lauterbach said this all was key on the August 25th meeting. Well, they were all usurpers and illegitimate from that time on. A, it is first noted that Senator Shirky is not a delegate or resident of Hillsdale County, although he is a former ex officio member as a state senator. B, following the competing conventions, the MIGOP State Committee Chairperson Ron Weiser recognized in writing the executive committee from the 2022 election, from the 2020 election that called the county convention on Manning Street as the executive committee as being lawfully elected. This interpreted the Manning Convention is the only, the only proper convention recognized by MIGOP. This administration is bound by that determination, but also agrees with the reasoning. C, this lawsuit is brought in the name of the Hillsdale County Executive Committee, but it is the Shirky-Leininger group that was not recognized in their claim to the title. So they're suing with a title that they don't own. That's called usurpation. 14, the fundamental issue is clear. There was a valid election recognized in November of 2020 of an executive committee, and that election was not overturned by the August 25th, 2022 special meeting. Therefore, the notice of the second competing convention at the fairgrounds by the Shirky-Leininger group is not valid. There is no authority, actual or implied, to call this convention. A, the valid convention held at Manning Street on November 17, 2022, elected an executive committee, and that executive committee selected officers whom are the officers recognized by MIGOP. And those officers are David Mosby as chair, Adam Stockford as vice chair, and you have Danielle Mentz as secretary. You have Jacob Brun as treasurer, Dan Rutan as deputy treasurer, and you've got Chris Wingate as parliamentarian. Those are the official elected officers and recognized by MIGOP. B, the second letter issued by Ron Weiser on December 28, 2022 is not relevant and moot. The letter represents that the MIGOP credentialing convention made a preliminary determination on attendance at the convention. It is preliminary as the convention body makes the final determination as to who sits. So it's the body at the state convention that makes that determination. The issue was not brought to the convention floor and is waived and moot because Ron didn't bring it to the convention floor. If the credentialing committee had made a recommendation, it is not binding on the state convention and has no effect on the county leadership. 2, the credential committee is merely to recommend to the February state convention which delegates can attend from Hillsdale, but the state convention does not resolve leadership of the party. As the convention has been held, this issue is now moot. 15, the resolution of the issue before this court is clear to MIGOP. The Article 3 powers permit this court to make sure that the law and internal process of the bylaws, as well as Robert's Rules of Order, are applied correctly to ensure a fair, orderly, and transparent process when the party is unable to resolve the matters internally. This court recognized this in the order denying the second TRO on February 2nd of 2023. That's when we first were all in the circuit court. A, MIGOP believes this court, if the court were to decide the dispute, the litigants as to who is in control is not proper, nor is this issue properly before this court. Begin with the lawful election of the executive committee and officers of the November 2020, which seems to be undisputed. B, second, this court determines if the special meeting called on August 25th, 2022 was not a lawful meeting with proper notice, and the MIGOP states that there are significant claim defects with the notice, that this is a material issue of fact. C, third, this court could determine there are no means in the law or bylaws to remove the elected officers of the Hillsdale County Executive Committee without notice, a right to be heard, and without cause. So no due process. D, after this court determines that August 25th, 2022 was an unlawful meeting or took an action not permitted by the law or bylaws, then there is no further controversy and the court should recognize the Manning Street Convention. E, there is a clear precedent in Macomb County and a copy of the order is attached, and I've got those copies. 16, while it has been asserted in the past that the court has no authority to intervene in the internal conduct of the political party, there is an ability to determine whether Michigan law was followed and the conduct of the party in accordance with its internal processes. The court cannot set those internal processes, but make sure that they are acting in accordance with the rules when the party is unable or unwilling to resolve the matter. 17, the precedent as to the removal of an executive committee and officers has already been decided in the Macomb County, and this persuasive opinion relates to the identical issue. Can a faction remove the executive committee en masse without any notice or any bylaws authorizing such action? It cannot. 18, there is the final matter of the court's temporary restraining order, in which this court entered an order dated November 15, 2022, from acting as leaders in the party and delivered it on November 17, 2022, and the subsequent claim for contempt. A, this order is likely entered after the court was misled about the authority of the special meeting of August 25th, 2022, and that with further time, the court would have not entered such an order. B, the order did not nullify the call to the convention that had already gone out. The convention proceeded with new leadership running the convention. C, the order did not authorize a competing convention. D, the order did not determine that Shirkey-Leininger faction was authorized to act on behalf of the Hillsdale Republican Party. E, the immediate resignation of the defendants on November 17, 2022 before the convention has made this relief sought moot and makes the claim for contempt to both be frivolous and moot as well. That was the amicus brief. And with that amicus brief, there was two opinions in order issued by the 16th Circuit Judicial Circuit Court in which the same matter happened. And it was and it was decided exactly the same way as was outlined in this amicus brief. So, thanks for tuning in for the third episode of Self-Evident Truth with the Angry Old Vet. That's everything right there. That's what it is. And even their lawyer admitted in court yesterday that it all hinges on the August 25th, 2022 meeting that they had at Olivia's that was improper, illegal, and uncalled for. And it was all done on ego. So that's my opinion on the matter. You need to form your own opinion. Use your critical thinking skills. Come to your own conclusion. Thank you, and with that, have a good night.